There's a rule about your Social Security that protects it from almost every debt collector in the country. And I was a bank manager for 19 years, and I did not know it. Not properly. I found out from a department in my own building. My name is Harold Briggs, 43 years behind a bank counter, and today I'm going to tell you exactly what is protected, exactly what is not, and where nearly every video on this subject is not being straight with you. Let me start with the day I learned it, because I have never forgotten how stupid I felt. A garnishment order came in. That's a court document telling the bank that somebody has won a judgment against one of our customers and that we are to freeze what's in the account and hand it over. I had seen them before, and this one was for a woman I had known for a very long time, a widow in her late 70s, and it was a credit card from years earlier that had got away from her after her husband died and the medical bills came. And I remember the feeling in my stomach, because I thought, that's it, they're going to take her money. So I did what a manager does, which is send it through to the department that handles those, and a woman there who had been doing that job for probably 20 years and whom I had barely ever spoken to, rang me back within the hour and said in a completely flat voice, as though I had asked her what day it was, "Harold, that's Social Security in that account. Most of it's protected. We're releasing it." And I said, "We can do that." And she said, "We have to do that. It's the rule." Now I want you to understand what I'm telling you. I had been in banking for over 30 years at that point. I was the manager of the branch. I had signed my name on a great many things. And a rule that decided whether an elderly customer of mine could pay her heating bill that month was something I had to have explained to me by a colleague I hardly knew, because it had simply never come up. And I'd wager that most of the people reading a garnishment notice at your bank today don't know it either. And I say that with no pleasure at all. So today, what is genuinely protected and by what? The bank account rule that almost nobody knows, including bankers. The exceptions, and there are real ones, and this is the part where I am going to disagree with some very popular videos on this subject. And the one mistake that turns a bad situation into an unrecoverable one, which I watch people make more than any other. Two thoughts before we start. The first, Harold, I pay my bills. This isn't me. Friend, I hope it never is. But knowing this changes something even if you never use it, because a great deal of the damage in this area is done by fear rather than by creditors. People make catastrophic decisions with their savings because they believe something is about to be taken from them that in fact cannot be. And the second thought, and I want to answer this one very directly. Harold, this sounds like you're telling people not to pay what they owe. I am not. And in about 4 minutes, I'm going to draw a line that most videos on this subject refuse to draw, so please stay for it. Because that line is the whole point of this video. So let's do the honest version first, and then everything else makes sense. Here is what is true. If you are living on Social Security, a pension, veterans benefits, or similar retirement income, that income is protected by law from ordinary creditors. A credit card company, a hospital's collection agency, a debt buyer who bought your old account for pennies. They cannot garnish it. It has been that way for Social Security since the 1930s. And pensions have their own protections under a federal law from the 1970s and under state laws besides. And here is what is not true, and I want to say it plainly because I have now watched several very popular videos say the opposite. This does not mean you do not owe the money. You do. The debt is still real. They can still take you to court, and they can still get a judgment. What they cannot do is take your protected income to satisfy it. Those are two completely different statements, and running them together is not a small thing, because the second one comes with consequences. The first one does not. It will affect your credit. It can mean court papers arriving at your house, and it can mean years of a debt sitting on your record. The honest sentence is this: if there genuinely is not enough money, the law has already decided that your food, your medicine, and your roof come before an unsecured creditor. That's it. That is what the protection is for. Congress did not make Social Security untouchable so that people could stop paying things they can afford. They made it untouchable so that a widow in her 70s would not be choosing between a debt collector and her heating. If you can pay, pay. If you genuinely cannot, you are not a criminal and you are not a failure. And the law is on your side in a specific and limited way. That's the whole frame. And now let's get into what it actually covers. Quick pause. My ebook, You Earned It Twice, lays out 52 practical calls you can make about Social Security, Medicare, taxes, and bills. It's the first link in the description. Now, protected broadly speaking, Social Security retirement and disability payments, veterans benefits, federal retirement, including postal and railroad, most pensions, and money still sitting inside a retirement account, which matters enormously, and I'll come back to it because it's the center of the biggest mistake in this whole video. Now, the bank account rule, and this is the one my colleague had to explain to me. Once your Social Security lands in your bank account, is it still protected? People assume it stops being protected the moment it becomes an ordinary bank balance. It does not. There is a federal rule, and it has been in place since around 2012, that requires a bank receiving a garnishment order to look back at your account and protect an amount equal to roughly 2 months of the federal benefits that were paid directly into it. 2 months worth. Automatically, without you asking, without you filing anything. And there are 2 details in that which are worth the whole video. The first is that it happens by itself. The bank's garnishment department is required to run that review and protect that amount before anything else happens. You do not have to know the rule for it to work, which is fortunate because I didn't. And the second is this. Within that protected amount, it does not matter where the money came from. If your daughter put a few $100s in to help you through a bad month, that money sits inside the protected balance too, as long as the total is within the sheltered amount. I have known families who were terrified to help a parent because they thought they'd be handing money straight to a collector. Within those limits, they weren't. 2 practical notes, and they are important. This works best when the benefit arrives by direct deposit, because that is how the bank identifies it, and it protects an amount rather than a whole account. If you have considerably more sitting there than the sheltered figure, the rest is not covered by this particular rule. If this is new to you, hit the like button, because somebody watching tonight is frightened of a letter and does not need to be. And subscribe. I do one of these every day. Now, the exceptions, and this is where I part company with the popular version of this subject, because I have watched video after video say, your Social Security is protected, full stop, with no qualification, and that is going to hurt somebody. The government can reach your Social Security in ways that a credit card company cannot. Federal student loans can be collected from it, and yes, a great many people over 60 are still carrying those, sometimes for a child. Federal tax debt can be collected from it. Court-ordered child support and alimony can be collected from it, and certain other debts owed to the federal government can be as well. Now, there are limits and protections and hardship processes attached to each of those, and I am not going to try to walk you through them here because they differ and they matter too much to summarize badly. What I want you to take is the shape. The protection is against commercial creditors, not against the government. So if the letter frightening you comes from a collection agency, this video applies. If it comes from a federal agency, it is a different situation with a different set of rules. And please do not let anybody on the internet tell you otherwise. And while we're being precise, there's a second category. Some debts are secured, meaning something is pledged against them. Your mortgage is secured by your house. Your car loan is secured by your car. Nobody needs to garnish your income to enforce those because they can simply take the thing back. So the mortgage, the rent, the car payment if you want to keep the car, your utilities, your property tax, your medicine, those are not in this conversation at all. Those you pay. What we are talking about is the unsecured pile. The old card, the personal loan, the hospital balance that's gone to an agency. Now, the harassment, because that is very often the real injury. There is a federal law about debt collection practices, and it gives you a right that hardly anybody uses. You may write to a collection agency and tell them in writing to stop contacting you. Once they have that letter, they are generally required to stop, apart from telling you about a specific legal step they intend to take. In writing, keep a copy and send it in a way that gives you proof of delivery. But I want to be straight about what that does and doesn't do, because this is the other place the popular videos oversell. It stops the phone ringing. It does not make the debt go away, and it does not stop them from filing a lawsuit. So it is a genuine relief, and it is not a solution, and anybody presenting it as a solution is not telling you everything. Now, the question I asked myself for years afterward, which is how a branch manager gets to his 50s without knowing a rule that decides whether his own customers eat. And the answer is uncomfortable, and I'll give it to you straight. Nobody in that building had a reason to tell me. The garnishment department knew it because it was their entire job, and they applied it 100 times a week without thinking about it. the way you or I would tie a shoelace. It had never occurred to them that the man out front didn't know, because to them it was as ordinary as the opening hours, and it had never occurred to me to ask, because a garnishment order looked like a court document, and you do not argue with a court document, you pass it along. And on the customer side, it is worse than that, because the people this happens to do not ask anybody anything. That is the part I most want to say. In 4 decades, I found that debt was the one subject where people went silent. They would tell me about a divorce, a diagnosis, a son in trouble. They would sit at my desk and tell me things they had not told their own children. But a person behind on a credit card would come in, do their business, and say nothing. And I would only find out because the letters started arriving at the branch. So you have a rule that is genuinely protective, sitting inside an institution, known only to the department that applies it mechanically, concerning a subject the affected person will not raise with anybody. That is a near-perfect design for a piece of good news that never reaches the person it was written for. Not a conspiracy, just silence meeting silence. And now the mistake. This is the one I most want you to hear, and it is the reason I make these videos. When people fall behind, and they are frightened and ashamed, the money they reach for is very often the money in their retirement account, because it feels like their fault, and they want it fixed, and there it sits. And here is what that does. It takes money out of the one place that was fully protected, and it hands it to the one kind of creditor that could never have touched it, permanently. That balance is not coming back. Nobody is putting money into a retirement account at 78. So somebody who was, in the eyes of the law, entirely safe, makes themselves genuinely poor in order to satisfy a claim that could not have reached them. I watched a man do exactly that. I processed the withdrawal, because it was his money and he was entitled to it, and it was not my place. He drained a good portion of what he had to clear 2 credit cards after a bad stretch with his wife's illness. And he told me he felt better, and I believed him, because the shame of it had been eating him for 2 years. Then he lived another 11 years on less than he needed to, and the last few of those were hard in ways they did not have to be. And I want to say the same thing to you that I wish I had said to him. That was not a debt problem. That was a shame problem, wearing a debt problem's coat. He could afford the shame far better than he could afford the money. So if you are in that spot, before you touch anything protected, talk to somebody who knows this area and who is not selling you anything. Every state has legal aid services for people on low incomes. There are nonprofit credit counseling agencies, and the honest ones will tell you plainly whether you should be doing anything at all. And if it is a hospital bill, ask the hospital directly about their financial assistance or charity care program. Many are obliged to have one. A great many people qualify who assume they don't. And in some cases, it can be applied to a bill you have already been sent. Let me tell you how it ended for the widow, because I began with her and it would be wrong to leave her there. Her account was released, and she kept the money, and she paid her heating that month and every month after. The debt did not disappear. There was a judgment against her name for years, and I have no doubt it was recorded somewhere, and that some computer somewhere held it against her. And she was 78, and she was never going to borrow money again in her life. So what that judgment actually cost her, in practice, was very close to nothing. But here is the part I remember. When I next saw her, and I told her plainly that they could not take her Social Security, that it was not a favor we were doing her, and not something that could be reversed next month. She cried at my counter. And it was not about the money. It was that she had spent something like 14 months believing that at any moment, everything would be taken and she would have nowhere to go. 14 months of that. And the whole time, the thing she was frightened of was not legally possible. That is what I mean when I say the fear in this subject is bigger than the reality. She did not lose money to that debt. She lost more than a year of her life to it. And she lost it because nobody told her a rule that had already been sitting in the law since before she was born. So here is your week. And this one is short because most of you will not need it. If you are getting collection letters and you are living on retirement income, 1, find out plainly whether your income is the protected kind and whether the debt is commercial or owed to a government body, because those are 2 different worlds. 2, make sure your benefits arrive by direct deposit into an account that isn't cluttered with other large balances, because that's how the protection works cleanly. 3, if the calls are the thing making you ill, send the written request to stop contacting you and keep a copy. And 4, Before you take $1 out of a retirement account to pay an unsecured debt, speak to legal aid or a nonprofit counselor first, not after. That call is free and it is the single most valuable hour available to you. And if none of this is your situation, then do the one thing that costs you nothing. Tell somebody. Because the people this is happening to are, in my long experience, the very last people to mention it. They do not tell their children, and they do not tell their friends. If you say out loud in the right room that a person's social security cannot be taken by a credit card company, somebody will go quiet, and that somebody has been frightened for a year. Then leave me a comment. I want to know whether anybody has ever explained any of this to you, by a bank, a lawyer, anyone. And if you have been through it, tell us what actually happened, because the fear in this subject is far bigger than the reality, and the only thing that shrinks it is people saying so out loud. I read every single one. And subscribe, because next time I'm going back to something a good deal lighter. The small recurring charges that arrive in a retired household every month and grow faster than anything else in the budget, including the ones people keep paying because stopping them feels like admitting something. Now the important part. Everything I have shared today is general educational information from a retired banker. It is not legal or financial advice, and I am not an attorney. I am not telling anybody to stop paying a debt they can afford. Exemption rules, garnishment procedures, protected amounts, and the treatment of government debts vary by state and by circumstance and change over time. And the consequences of not paying a debt are real and include judgments and damage to your credit. If you are in genuine difficulty, please speak with a legal aid service, a nonprofit credit counselor, or a qualified attorney about your own situation before acting on anything you have heard here or anywhere else. That is not me covering myself. That is just sound banking. If you want more plain banking lessons that help you protect what you earned, subscribe to the channel. Look after your money. You earned it twice. Once when you worked for it, and once when you kept it. I'll see you in the next one.